Hi, welcome to another episode of Yuskogan's The International Law Podcast. Today we are joined by Dr. Ioannis Kalpouzos to discuss his article titled Double Elevation, Autonomous Weapons and the Search for an Irreducible Law of War, which is published in the Leiden Journal of International Law. Dr. Kalpouzos specializes in public international law, international criminal law, the law of war, and human rights law. He is a visiting professor of law at the Harvard Law School and is the co-founder of the Global Legal Action Network. Previously, Dr. Kalpouzos has also taught at, among others, the King's College London and Boston University School of Law. Thank you so much, Dr. Kalpouzos, for joining us to discuss this very interesting topic. So just to roll off the discussion and before we go deeper into your article, give us a broad sense of how your thought process looks like in terms of AI and the law.
Yes, so thank you very much, Shayan, and it's wonderful to be with you in this podcast, and I've listened to some previous episodes with great interest, and I encourage our listeners to do so as well. And my engagement with AI and law has been in the context of international humanitarian law, law of armed conflicts, and international criminal law. But as your first question suggests, it does touch on some broader issues, right, that have to do with the interrelation of artificial intelligence and law, and that have to do with, I guess, both the hopes, aspirations on the one hand, and the fears that we encounter when we look at the interaction of these two fields. They are hopes and aspirations and fears that are very much, I think, ingrained in our present social and I would say epistemic moment, right, in terms of establishing knowledge and in terms of establishing decision-making and judgment. And the role of technologies is a topic that is hotly debated across different areas of law, especially, I would say, perhaps in a way that's more relevant to our specific topic, public law, right, including administrative law and including criminal law, which is, after all, a form of public law. And the extent to which artificial intelligence can assist, can enhance, but also to the extent that it poses problems, dangers, difficulties in legal decision-making and judgment is something that is a very active concern. And to the extent to which, and I think this is a theme that's very present in our in this piece and in the discussion on IHL in general, that it rationalizes, right, that it allows the further rationalization and rational application of law to the facts, or the extent to which it includes, codifies certain pre-existing structural biases. That's also a question that has very much been at the forefront of the discussion of that interrelation.
That's quite fascinating, because when as a student of public international law, whenever I think of autonomous weapons, emerging technologies, IHL is probably the first thing that comes to my mind. So in terms of just the title of your article, I see that you get a sense of, the law of war and then autonomous weapons, but there are other words like double elevation and the search for an irreducible law of war. So the title gives some things away, but it doesn't necessarily very obviously give other things away. So if you were to give like a spoiler-free version of what your article is about, what exactly, how would you describe it?
Spoiler-free, huh? So I would say that it is about how the interrelationship between technology and law serves, for better or worse, this what I call double elevation, which is an elevation which is an elevation in terms of power, but also an elevation in terms of rationality and civilization and morality against both an enemy and also ourselves, right? And I look at, and I think this ties in with what we said at the beginning in terms of the interrelation between artificial intelligence and law in general, right? There are these two forms, if you will, of elevation, or another way of putting it is distance, right? But elevation also suggests a certain asymmetry. It suggests a certain, privileged position from one side to the other in that relationship of distance. And that relationship of distance is both, in some ways, physical distance, is this distance in terms of access, and in distance in terms of proximity, but it is also moral distance, right? Because there is an elevation in terms of the rationality of the decision and the idea that technologically infused processes are more advanced than those that are not.
This is quite interesting. So perhaps it would also, now that we've gotten a broad sense of it, perhaps it would be helpful to sort of start breaking things down as they've been broken down in the article. So maybe perhaps we can start with, what you think about, or how would you define the term autonomous systems, and how do you differentiate it with this term that you use frequently in the article, merge heteronomy? So what are the examples of these two terms? How would you define them? So if you could just elaborate a bit on that.
Yeah, so the traditional approach to discussing this is, so I guess it could be seen from two angles. One is the degree of autonomy that a particular artifact, in this case a weapon, has in decision making, right? In both kinetically and cognitively. So to what extent it can exist outside in the world, and to what extent it can make its own decisions independently. And conversely, I suppose the other side of looking at it is how involved does a human being need to be in the process of that decision making? And I'm trying to put it in, more or less lay terms for it to be understood. And this is then discussed sometimes and approached usually as a continuum, right? To ranging from something that is able to just directly respond to certain stimuli and have that form of automaticity, right? While at the same time being operated and handled by an individual. Weapons or artifacts more generally that have a broader sort of sense of possibility and freedom in that context, but that still require an individual to be operating them and be, the term is sometimes on the loop, and reaching the level of full autonomy, at least that's the usual trajectory, where from the point of deployment, if you will, through the process of target identification and sometimes including the necessary kinetic function, but ultimately leading to the engagement of the target, the weapon is able to operate autonomously and does not require, or in some cases, cannot even have, to the extent that there isn't connection with the individual, the involvement of the individual in the loop in terms of giving the green line, pressing the button, and so on. So you have that idea that, you have the image of a robot, right? And the idea of the full autonomy of the robot is, with appropriate references from, movies and Terminator movies and so on and so forth, their capacity to operate in the field and in the military field and behind enemy lines and in denied territory and so on and so forth. And I say that, that is the general approach of viewing autonomy, but I think that it is limited, and it is limited in two ways. One is that it only pictures and separates that weapon as it engages with the actual targeting decision. And indeed, artificial intelligence, and that's very important to keep in mind, is operational in weapons that sometimes will be placed in the combat zone and will engage targets directly. But it is also a feature of a broader cycle of targeting in terms of object identification, object classification, object analysis that feed in the targeting cycle and influence the decision-making of individuals in that process, right? So in that sense, artificial intelligence has a significant influence on targeting and therefore on the law of targeting at a broader cycle. And that's something that the trajectory from automatic to autonomous doesn't necessarily and fully capture it. And the second way in which this is limited is that notion, as you said, of merged heteronomy, where there is indeed a separate or parallel what's the word, agency, if you will, of the human and the machine actors, but they are merged, right? And one way of viewing that merger is in what I just described, in a, as it were, socio-technical system of humans and machines interacting, exchanging information, judgments, classification in a structure, right? In a military structure, for example. And another one is a much kind of, as it were, closer merging, which is physical and even biological merging, which is computer-enhanced cognition, in some cases developed within the body and within the mind of individuals, either through the use of gear, right, that they wear and that allows them that enhancement, or through other forms of slightly futuristic but not that futuristic types of cognitive enhancement and biotechnology and so on and so forth. So, and in that case, those agencies and that exercise of judgment are merging, right? So we cannot talk about it and regulate it purely by the image of this kind of free-ranging, running wild little robot, right, that is engaging targets. But the artificial intelligence and the human intelligence and the AI decision-making and the human decision-making are merging and are interacting and are influencing each other.
So in terms of the second strand that you mentioned, merge heteronomy. So in that you give this example of sort of this Iron Man suit that's being developed called the Tactical Assault Light Operator suit. So to my mind, but when I think about it, I think about the fact that even if it's, for example, a hypothetically speaking, an Iron Man suit is fully functioning and it's being deployed in the battlefield, the human would in effect be in the loop, and if anything, perhaps be in control of the suit itself. So in that context, is then merging the question of the development of autonomous systems and how it intersects with the law, isn't that a different question? Because in effect here you would always have humans taking the lead on how a weapon is being operated. So for example, if a pilot is operating an aircraft, how would that be any different than, for example, being in an Iron Man suit, so to speak?
Yeah, so you're right. If we are going to approach this through the terminology of being in the loop or on the loop or out of the loop, the individual in your example of the Iron Man suit would very much be in the loop, will be, in some ways the entire loop. But as I say in the article, the loop itself is changing, right? And, the loop itself is changing in that example of that physically merged form of human and machine intelligence. And indeed, as one of my favorite pieces on this by Professor Gregor Knoll puts it, in some cases, to the extent that neurotechnology has been introduced in providing for artificial intelligence enhancement of decision-making, you may say that an individual is making a decision, is making a judgment, but are they really, right? And even before or outside that narrow, if you will, and to some extent, not entirely, but definitely to some extent futuristic development, there is the example that we mentioned before, which is the human machine merging not in the body of a human being, but in a targeting cycle. right? Which allows the individuals to be in the loop or at different points in the loop in that process, but ultimately creates a loop that is increasingly influenced by the results and the contributions of artificial intelligence in terms of, as I said, identification, classification, and the development of the decision-making in that process. And in that process, a lot of also philosophers of technology have discussed a variety of potential biases that might occur and that occur in the relation between human beings and technology. By the way, research that doesn't only focus on military technology and weapons, but has a few decades of history, right, in looking at that type of interaction, which includes, in some instances, the confirmation bias, which is, of course, something that is very much linked to what we were saying at the beginning in terms of the perception of a higher degree of intelligence and rationality that exists in machines, right? And which also may very much depend on the specific social relations and the social position of individuals in those contexts, right? And to move towards, I suppose, the core of the argument, to the extent that law has been codified in a way that can be input in those artificial intelligence systems, then, and to the extent that one relies, one has green-lighted, one has accepted that codification, right, of the law as a whole or of specific aspects and parts of the law, there will be an even arguably greater tendency and temptation to defer to those systems' judgment because they have been cleared to apply those elements of decision-making that are legally relevant, right? So the individual remains in the loop, but the loop, including increasingly the legally relevant aspects of the loop, right? The aspects of the loop that do actually apply the rules or the classifications that are relevant to the rules are changing and are becoming more and more infused by artificial intelligence.
So just to revert back to autonomous systems more generally, there's this very interesting example that you mentioned of Project Maven. So could you give the audience a sense of what that is? Because I found that to be a particularly interesting example.
Yeah, so that's something that started a few years ago, and it was a significant project of at the US of the Department of Defense, which worked with private corporations, including Google, and which was effectively a series of testing algorithms for object classification in so-called sprints. Short periods of application of visual technology for the recognition and classification of objects. And I mean, not in the entirety of the project was transparent and public, and the idea was that this would occur in the abstract in terms of developing the capacities of these neural networks, this artificial intelligence in classifying objects. But those practices of classification were live, so they were referring to and using the footage that the millions of hours of footage that the US gets from surveillance drones and other forms of visualization from the field and from the military field. And indeed, they were fed back to the areas of operations and presumably also used in the context of the areas of operations. In fact, it's quite clear that they were, right? So there was a process of training algorithms in order to improve their capacity to classify objects. B, that process was serving the general increase of the technological sophistication of the military in that context. And C, those were and definitely were meant to be eventually related and connected to the field of operations on the ground. And famously, there was eventually at some point a revolt by Google employees that didn't like to be associated with that project, which ended Google's engagement with that project. But Google has been and remains engaged. I think recently somebody put on the internet from the Google website that they openly say, we are happy to serve to achieve the goals of the Department of Defense, right? And indeed, that public-private partnership is at the very heart of artificial intelligence development, and it's at the very heart of the military aspect of artificial intelligence development in the US, but also elsewhere, right? In the UK as well, in other countries like Turkey, and it's the way that this works, which of course follows very much the history of military technology, right? Which is one area where the state and the private actors have been in significant, confluence in developing that type of technology.
So in another point that you mentioned in regards to this project is with regards to the fact that the Department of Defense directive says that there needs to be an appropriate level of control by the commanders and the operators. But then when you look at the sort of this scientific progress that the US is making, it's towards autonomy, but on the other hand, the law is sort of in this tension where it sort of stops you from doing that, but then states are also sort of developing and going in this direction. So how do you see this tussle going about? Do you see, as we go forward, a change in domestic laws as well in terms of, what the limits might be of autonomous weapons, and sort of how this reconciles with just international law generally?
So that's a very good question, and this notion of human control or appropriate levels of control or meaningful human control is a term that has been at the very heart of this conversation and has been at the very heart of some scholarly writing on this, but also crucially of the way that states and some states have been talking about this. Including at the level of state negotiations in the framework of the of a specialized convention for the regulation of certain conventional weapons, which has been debating, right, these developments in the future of autonomous weapons. And it has served as a red line, if you will, for not losing control in terms of the operation of such weapons. But occasionally, it can be argued, is a red line that is much grayer than it is red, right? And exactly what constitutes meaningful human control is difficult to tell. And it may be that one can draw a line when one approaches this issue from the trajectory of automatic to autonomous, right, that we were discussing, and through the discussion of the loop. But, I think the value of challenging this particular trajectory and the value of highlighting the various forms of merging between artificial intelligence and human intelligence, either socio-politically, socio-technically, I should say, or biologically, is in showing that it's very difficult to draw that line, right? And that is something that I think plagues the conversations internationally in terms of the future of autonomous weapons. It is something that is a problem in terms of regional, like the EU, or domestic types of legislations in relation to that. And it's also something that I think poses problems for those who are interested in opposing these developments, right? Because it makes it harder to draw a line in the sand in terms of saying what is too much, what is too far, what is not to be accepted.
So transitioning to sort of what I think is perhaps the most important part of your article, it's double elevation, rising above oneself and above the enemy. But before we get into what you actually mean when you say that, I was quite interested to know how what was your thought process in formulating just this whole narrative, and what thinking went behind saying that, okay, there is a double elevation, and how sort of this ties in. So while writing this article, what was your inspiration? How did you sort of arrive at double elevation generally in this context?
So in two ways. One is thinking about the extent to which the idea of a quote unquote paradigm shift is accurate and useful. And secondly, in thinking about this in the context of understanding the development of both war in general, but also the way that law is regulating war, as moving from a horizontal to a vertical plane, right? Moving from a situation of formally reciprocal, equal actors to a situation of effectively distanced and potentially global governance, right? And, and both of these questions, I think, had been posed and have been, part of the discussion over the last 20 years, also and especially perhaps in relation to the use of drones, right? The extent to which drones are really changing the game, changing the paradigm, changing the system, or the extent to which they follow trajectories that existed already in the past in the context of aerial bombardment, in the context of colonial warfare, and so on and so forth, right? And, and when discussing autonomous weapons, because of the fascinating and either from a positive or a negative kind of perspective, unprecedented aspects of some of these technologies, there is a tendency and a temptation to talk about a paradigm shift, right? There is a tendency to talk about this is completely different to everything that existed before, right? So I wanted to understand whether it was different, how it was different, and how it fit with what existed before, hence those terms.
So when we talk about rising above one's enemy as part of this elevation process, what exactly do you mean, and what sort of historical examples can we look to sort of situate this into context?
Yeah, so the story of military technology has been, in a way that's also partly rather obvious, a story of trying to establish superiority in the battlefield against an enemy, superiority in military terms, and that sometimes has been seen to be served also by the capacity to strike from a distance, and indeed the evolution of early 20th century and mid 20th century war reflects that, right? So I start with one example, which is which comes from the memoirs of Churchill when he was engaged and fought in the Boer War, and when through the use of rifles against the population that did not have rifles, he recounts a confrontation that was a particularly mismatched, technologically speaking, confrontation, and he refers to the I forget the exact phrase, but the physically tedious act of killing, effectively, right? And while at the same time says that this was one of the great victories that science had over barbarism, right? And in that instance, you have that military superiority and elevation, you have a degree of distance, right? Physical distance in managing to achieve defeat, but you also have a elevation and a distance which is, asserted as cultural and civilizational in that particular conflict. And that cultural and civilizational distance might be sort of generally associated with colonial warfare, but it's also linked to the technology and the capacity of the technology, right? And the same was the same, if you will, considerations and aspirations were part of aerial bombardment from the 1920s and colonial warfare, but also through the Second World War and through the period of decolonization. And I have some examples there of the Vietnam War and the temptation and impetus to create an automated battlefield in the context of the Vietnam War. And if somebody looks through some of the language that was used by, for example, General Westmoreland at the time, they could have been talking points today, right? The kind of vision of automation and integration of the technological capacities and the capacity to visualize, rationally and automatically identify and engage a battlefield and an enemy from a distance were very much present there, right? So that distance is above the enemy, and it is physical distance, and it is moral distance, and it is also cultural and civilizational distance. And I think, and I understand the evolution of the 1980s and 1990s practices of war that led to the development of targeted killings and assassinations extraterritorially, and that led to the development also of drone technology in the 1990s, to be very much connected with that tradition, and indeed autonomy to be part of the fuel to establish this type of elevation and distance from the enemy.
So this is in terms of the geographical and the physical distance, and that sort of becomes apparent as for example, you're sitting in one country and then you can just use a remote and operate a machine and target other objects. But in terms of just the moral and civilizational distance, so to speak, in the historic times, for example, you mentioned the example of Churchill, becomes, you can see what the sense of or what the mindset is in terms of that civilizational superiority. But in the modern battlefield, how do you situate morality and the civilizational superiority in terms of the modern warfare, and how sort of that plays out in terms of elevation?
So in the last couple of weeks, we've had some reports, for example, in relation to US activities in Syria, as we had over the last month or so in the context of Afghanistan and some of the strikes there. And the talking point that you keep hearing is that, and that keeps being repeated even in reports and pieces that are written to expose, right, some of the arguably unlawful acts and definitely quite destructive acts in that context, about the most humane and the most discriminating and the most precise war in the history of war, and so on and so forth. And that is also very much the rhetoric and the logic, specifically in the context of the development of artificial intelligence, right? The national security strategy in the United States, in its arguments for the prioritizing and the development of artificial intelligence research and integration with warfighting. On the one hand, of course, it talks about the competition that exists in that field and the need for the state in the United States, like every country, to be on top of that competition, but also talks about the civilizational elements in developing that form of rationality and that form of precision and that form of capacity to make these sorts of decisions in the field. So it has never stopped. And it is something that, we'll come back to that, is something that we say to ourselves, right, about how good we are. But I also think that it is something that we say about ourselves in relation to those that we fight, right? And that has definitely been the case in these recent examples in Afghanistan and in Syria, right? What better enemy to assert this rhetoric against than ISIS, which has served as the paradigm of the very opposite,
Absolutely, that's quite an insightful point. In terms of the second elevation, though, right, elevating above oneself. So what does that exactly entail?
Yeah, so as I said, we say that to compare us and to establish our cultural and civilizational distance and elevation above the enemy, but this also serves a narrative of self-improvement, right? It serves a narrative of increasing the degree of our civilized power, as it were, in relation to our own war-fighting, decision-making, and judgment. And within this, the idea that human judgment is fallible, that human subjectivity, especially in the context of the fog of war, is problematic, that quote unquote robots don't rape, right? And that the codification, rationalization, outsourcing, in effect, of some of these decisions to agents that do not suffer from some of the failures and weaknesses of humans, is a form of self-improvement, right? And it is an elevation above ourselves and above the frailty of our human judgment. And that can be seen also if you look at it from a, I guess, governance perspective. So a lot has been written, for example, on the role of governance techniques, the processes of review, the processes of creation of lists, right? In the way that war is being conducted, right? And war is seen as a form of governance. And there is also, by the way, a lot of literature that kind of stretches war as governance all the way back to the 19th century. But today, as a rational governance, right? A way of acting violently while acting rationally, right? And that is, of course, connected very much with humanity and humaneness. Of course, it also connects with, the argument in Sam Moyn's recent book, Humane, about the way in which, cooperation and a cooptation between military professionals and humanitarian professionals is serving the humanization of war through the application of international humanitarian law, especially to the extent that that is integrated in governance structures, and especially to the extent that it is also aided by technological structures in that process, right? And that, I suppose, the ultimate idea would allow a type of civilized, humane, and rational form of potentially global war in this context.
So a subset of this part of elevation would just, as you mentioned as well, is just some schools of thought thinking that you can humanize war by advancing autonomous systems. For example, as you mentioned, the fog of war, lifting that off, because to make very rational, calculated decisions. So beyond just the discussion of it not fitting into, like the pragmatist military lawyer approach, beyond it just not fitting into the current regime on the law of war, why do you see that as problematic? Wouldn't it, in theory, just not solve problems if it's just mechanized and if it's programmed, and then let a very mathematical sort of IHL come into play? Like, well, why do you think that's problematic?
Yeah, so that's really the kind of central and perhaps in some ways most difficult question, right? So, of course, I'm not arguing for the unlawful use of these technologies and these weapons, but I see, as I say in the article, law to be part of the same, not all law, but some at least approaches to law, right? To be part of the same rhetoric and the same trajectory and the same logic, right? That to the extent that human decision making is codified through law, then it is rationalized. And if only it could be applied properly, then that would either solve problems or would be the best that we could achieve in this context, right? And that is an approach to law that to some extent sees, I think, law as potentially codifiable and sees the question of autonomous weapons as a question of technological capacity, compatibility, and adaptability, right? Does a particular system have the capacity to distinguish object A from object B? Does a particular neural network algorithm have the capacity to conduct a proportionality calculation if it is given certain values in relation to the military advantage and the potential civilian casualties anticipated, right? Is it possible to quantify and to articulate in that form of codification these types of legal classifications and legal operations, right? And I think that that approach is an important starting point, but I think that that approach has certain limitations in terms of what kind of answers it can give. And that also that approach places some of these questions effectively in abeyance, right? It says effectively, currently the systems are able to satisfy X amount of legal rules, but are not able to satisfy the rest of them. When they come and they say we're able to do that, then we'll see and we'll apply those issues at that point, right? And ultimately, what this does is I guess, encourages the development of that technology in order to meet those particular demands, right? And therefore the investment of that type of technology in order to meet those demands. And B, encourages the gradual, deferral and outsourcing of human judgment to that form of codified legal artificial intelligence, right? So it accepts the premise, right? It accepts the premise that it will be better to act in that way and to outsource judgment and decision-making to machines from a sort of a practical functional point of view, right? And says, law is here with this set of rules, we will apply them to the extent that they apply like that in the future, right? And fundamentally, that approach sees law as something, as a kind of logic that can be codified and can be, as I put it, reduced to algorithm, right? Why? Well, partly because a strand in legal thinking has always wanted to have things that can be codified and can be placed in these tight rational categories and that are not particularly tolerant of irreducible subjectivities in the ways that these are being applied in practice, but also discussed and analyzed. And the thing with law in general, but also in certain very particular ways, international humanitarian law in particular, is that that's not the case. And that doesn't represent the law as it stands. And it also, frankly, doesn't represent for what the law stands, right? Which is a type of situated subjectivity in a context and a situation where an individual is acting and in many cases risking their lives for the collective, and in that process is killing and is destroying for the collective, right? And that entails and engages a degree of moral agency, a degree of participation that is part and parcel of the decisions that engage international humanitarian law, right? And of course, again, it may be easier to imagine that by imagining an individual in the actual operational ground in the fog of war, being endangered and so on and so forth. And that is, I suppose, to some extent, diluted when you look at the broader targeting cycle and the different degrees and levels where individuals are making decisions in that particular cycle. But it doesn't change the fundamental position, right? That these dilemmas, which are moral dilemmas, but are moral dilemmas that are integrated in the very context-specific and subjective, but not necessarily kind of radically indeterminate in a nihilistic sort of way, right? But fundamentally subjective assessment of values in applying international humanitarian law in those processes cannot be reduced or should not be reduced to algorithm, right? And that is, by the way, something that I approach it in this article by borrowing from some philosophical and sociological thinking in the critique of artificial intelligence from the 1950s and 60s onwards, right? But it is also something that I think is present in some of the responses of more mainstream legal approaches to this, right? So increasingly, I would say that for example, ICRC has stepped away from a kind of narrower compatibility approach, or rather has perhaps taken the compatibility approach and extended it in or heightened the threshold to say it's not just a question of whether the machine can distinguish a tree from a bush, right? It is that there are certain value judgments that are integrated in those legal rules that, by definition, artificial intelligence cannot and should not be able to make. And the merging of this cannot and should not is also, I think, important, right? Because, when you say cannot, the other person can say, why not cannot, right? If you come to me and you have, ideally, let's say, a really detailed list of all of these potential military targets, right? And you ask the military officials to assign numerical values to those, right? And in that particular context of the war, you also assign numerical values to types of loss of civilian life or destruction of civilian property, and you establish, and I'm just sort of mentioning the two most basic kind of patterns, right? But you also potentially input the value of some broader contextual elements in terms of the strategic importance of specific actions in that way. Why not have an algorithm that being able to produce that? So the cannot be discussed on a purely, if you will, technical basis, right? It needs also to be discussed at the basis of what it is we understand in the context of law, the values that are inherent of law, but also the type of cognition that we are discussing, right? Which is not just cognition in terms of accurate recognition of certain items. It is also a cognition which is situated, which is has a degree of subjectivity and involves value judgments while acting, an embodied cognition, right? Socially embodied and physically embodied cognition, that process.
It's quite fascinating, and I think this serves as a sort of a good transition point to sort of get your thoughts on why you were against double elevation. So you mentioned, there's a certain level of angst that's there, and then, for example, you mentioned that irreducible intelligence and irreducible law. That's one of the other headings. So starting with angst. So what exactly is the fear? And I know you've touched upon this in some ways in the previous question, but what exactly is the fear in terms of double elevation?
Yeah, so the fear is the fear of dehumanization, and the fear is the fear that has existed from ancient times, that are reified wishes, the artifacts that we create and that we endow with these powers will escape our control and will take over, the sorcerer apprentice and all of that, as well as I think, fundamental moral discomfort with the delegation of decisions that have to do with life and death to artificial forms of reasoning and machines, whether these machines are, freestanding robots or whether they are algorithms that operate in different contexts. And I share some of that angst, as you can tell and as you can see. And the question is, what's law got to do with that, and what can law do in that particular context? And so, as I mentioned earlier, I in general support the ban killer robots, as it were, campaign in that context, but I also think that to the extent that that campaign relies on this sort of shift of paradigm idea, it doesn't accurately reflect really the long tradition of what is happening, right? Of that double elevation and how that is accentuated and reinforced through artificial intelligence. To the extent that such a campaign relies on this idea of full autonomy, which doesn't take sufficiently into account socio-technical or indeed physical merged heteronomy. And to some extent, they do take it into account, to be fair, right? But to the extent that it also motivates people purely on the basis of that individual killer robot approach, I think it misses the target, and it also allows or doesn't engage perhaps enough the development of artificial intelligence in a myriad peripheral ways that ultimately, inundate and overwhelm the decision making in that process. And then I also think that, for me as a lawyer, but also to the extent that we do engage law in that process, the question is exactly how do we approach and how do we use law, right? And I don't have a particularly, I think, good answer in that, but partly because I'm not one of those lawyers that thinks that law is necessarily the answer, but also partly because I think that there often is the danger that the power of law to both prescribe and regulate can be fetishized, right? And the appeal to law in order to limit and control some of these powerful both military and economic forces may be limited. But at the same time, I recognize that there are elements of value in the law, right? Both in integrating certain values of humanitarian protection, but also in trying to articulate the dilemmas that we face when we fight wars, right? Both from the humanitarian side, but also from the enabling or legitimating side of using violence where we fight war. And that's why I think that at the end of the day, to the extent that law does reflect that human condition when fighting a war, that is the side of law that needs to be defended, right? And it is the side of law that is irreducibly human, which is the side of law that resists at least some aspects, because the law does not resist all aspects, but some aspects of that double elevation, right? And in some ways, it's the law that sometimes, despite itself, resists the elevation above human subjectivity, right? Even though laws often is proposed as a solution to human subjectivity, it also integrates it. It also acknowledges it, right? It also sort of channels it. And I think it's all the more valuable for that. And if we are to engage it, we need to acknowledge that, right? And if we are to engage it in the process of fighting the mechanization of judgment and the imposition of distance through the mechanization of judgment, that's the side of law that I think we should be engaging. And that's also in some ways, you know, sometimes can be seen as being a little bit in tension with what a lot of lawyers who engage international humanitarian law try to do, right? Because when we, and I say we because I also sort of actively work often in that direction, when we engage international humanitarian law, often we do seek certainty, right? We do seek certainty both for the future in trying to guide action as clearly as possible, right, through a variety of means: legal codification, military manuals, rules of engagement, and technology is one of these aspects, right? And we also seek certainty when we assess, right, an action that has occurred and whether that action violated the law, right? We seek certainty when we submit certain actions to judgment in a court, right? Or at least a certain degree of certainty that will suffice in establishing responsibility, including potentially individual liability, right? And we seek certainty when we try to articulate exactly what evidence is sufficient and is necessary to establish, right, the law and the violation associated with the law. So, you know, so a lot of the legal work that we do kind of strives for clarity, predictability, certainty, and so on and so forth. And technology comes and says, we want to do the same thing, right? Why don't you just let us do that, right? And but at the same time, diagnosing, if you will, that form of of double elevation and the distance and dehumanization which is associated with that form of double elevation allows us to, you know, step back and resist, right, that siren call for certainty and say, actually, you know, maybe certainty is not the only thing here, right? Maybe some degree of subjectivity and situated judgment is also important, right? Is this humanitarian? In some ways, it is humanitarian. In some ways, it isn't in terms of necessarily quantitatively speaking optimal results, right? Yeah. I imagine you're going to ask me about assessment now. I don't know.
No, thank you so much for the comprehensive answer. So when we throughout our discussion, we see targeting come and go, because I feel like this is one of those questions that when we think about autonomous weapons is a question that comes very frequently. And there's this certain quest of certainty that is there when we talk about in terms of targeting and in terms of autonomous weapons. So could you just take the points that you mentioned on certainty further and sort of also discuss your work that you're doing as part of the Global Legal Action Network on open source evidence and violations of IHL, and how the two have intersected with each other? I think that would be a good point to conclude this discussion as well.
Right. Yeah. So, right. So that engagement and that work, you know, comes from that other side that I mentioned, right? The striving for a degree of clarity, for a degree of being able to speak the law and determine the law, and for a degree of accountability associated with the law of targeting. And yeah, so as you mentioned, I'm apart from my or alongside and in the context of my academic work, I'm also a member of an organization called the Global Legal Action Network. And one of the themes and the areas that we work on is war and occupation. And within that, one of the aspects that we've worked on is targeting, aerial bombardment, and open source information, open source intelligence and investigations in that context, right? And one of the projects that I have been engaged in is a project related to the war in Yemen, where alongside colleagues, we established what is referred to sometimes as a hackathon. And we, with visual investigators from Bellingcat and the New York Times, developed an analysis of airstrikes in Yemen. Bellingcat created a website with some of these analyses, and we have since also been working in terms of looking at how open source intelligence evidence can be used in the context of international humanitarian law, as well as potentially international criminal law. And my colleagues, Dervla Minogue, Yvonne McDermott, have also worked on this and developed a mock trial where the judge, who is now currently the UK judge of the ICC, presided over a mock trial using open source intelligence. And I have, and with my colleagues, worked on a forthcoming report on IHL and OSINT, partly in collaboration with the advocates for human rights at the Harvard Law School, right? So all of that work, right, is not work that says everything is subjective, situated, et cetera, et cetera. It's work that tries to articulate, highlight, right, ways in which forms of knowledge and technologically assisted knowledge, and in some cases, even potentially AI assisted knowledge, because there are AI techniques that are being applied also for open source analysis and classification for evidence purposes, right, contribute to determining the legality of an action or not, right? And that's, I think, and I hope, important, right, in trying to establish accountability, especially seeing, you know, the recent example with the airstrike in Syria that took 2 years to come out, and that went through various layers of, what's the word, cover-up, right, is especially important, right, to highlight exactly what a lot of work we have to do in establishing transparency and establishing knowledge and countering the monopoly over information and over establishing certainty over the legality of certain actions that certain actors have, states primarily, right? But in that process, you're also increasingly realizing that in order to establish the legality, you have to apply a process of inferential reasoning that does need to recreate the mind of the commander, the mind of the targeter, the mind of the individuals who were part of the targeting cycle at different points, right, before the airstrike, you know? And therefore, what you see on the ground and what you see as a result is, of course, meaningful in a lot of ways, but it is almost always only part of the story, because it is just elements that you need to use to recreate the epistemic reality of the individual who decided to apply the law in that process, right? And there again, you are confronted with degrees of, you know, context, subjectivity, and situated judgment, right? And one way of approaching that is trying to reduce the elements of uncertainty, subjectivity, and, you know, reach a core of a position that you can say, and you can say, you know, clearly I have enough here to tell me that, you know, that particular action was within the core of the legal prohibition, right? And therefore it was an indiscriminate action. It was a disproportionate action. There should be state responsibility. There should be liability in that sense, right? And it's fine to do that. At the same time, you need to take into account and you need to appreciate and you need to assess that position that that individual was in, right? And I would add, importantly, you also need to be conscious that you are coming ex post facto, and especially to the extent that you're applying open source evidence from a distance, right? You have a particular situation in what you see and what you can tell, right? And only by starting from that point of I am who I am in that process of establishing and telling international humanitarian law, and the individual who was a state agent and also an individual that I'm looking into was at that particular position, only then can you match the certainty with the uncertainty, right? The objective determination that this is the law that exists and this is a law that has been violated or not violated with the more contextual and subjective aspect of the law, right? And the same applies to a judge, right? To the extent that judges have tried to act as certainty machines and to quantify certain things, they have failed in international humanitarian law, right? And in international criminal law that applies to targeting. It is, in my opinion, only when the judgment situates itself as an imposition of liability from outside that is able to do that work, right? And is able to go across. And frankly, and that might be something for another conversation, I think international criminal law is very far from being able to achieve that.
That's a good way to end off the episode. I feel like we should definitely have this discussion at a later point in time. Thank you so much, Dr. Kalpouzos, for joining us on the podcast. This brings us to an end, and we'll see you in the next episode.
Thank you very much, Shayan.
Thank you.